No.
Do you know Aaron? I can't think of his last name. He's with Roy. Aaron. He used to be LA. He used to be LA. Now he's in New York. Yes, yes. Okay. I can't think of his last name. Aaron. Yeah. Aaron Rainin. That's him. No, he does not owe me money.
She has family in New York that can collect, just in case.
No, but I remember he was Reuters, so I knew him. Yeah. He taught a Photoshop or Final Cut Pro class, so that was his side hustle. So I took the class from him, and then I started seeing him around downtown. So. He's big time. Yeah, he's like in New York. He's going to all like the big meet and greets and fashion things. He is out there. Yeah. He's awesome. Yes. Yeah.
No, you want to eat there? No, but he's not going to.
You go when they tell you.
He won't be able to.
Yeah. He did a documentary on the moon, like the space, the first moon landing, and he died. Did we go? So it makes you like, did we go? So he like his title is like, did we go? No, but that was just to get your attention to question, did we go? Like they said we landed.
AJ, you okay?
Yeah. You want to like this? Just kind of.
Yes, about that. I saw a little bit of it. And that was way.
That's so crazy. You guys hopefully will still stay. Never going down.
Yeah. It's a completely different market.
He's not going to be able to move. Yeah. Yeah.
That was a serious question.
Well, it was supposed to be before. We wouldn't know what to say.
It was supposed to be before.
Like a right now.
Oh, I see.
Anyway, that's exactly.
Is there a red chip?
No.
So that I'm ready to go. I think I'm just going to sit back here. Please.
Well, good afternoon, and thank you very much. My name is Nathan Hochman. I'm the Los Angeles County District Attorney. With me up here are prosecutors who made up the Menendez team. We have Ethan Milius, Seth Carmack, and Habib Bailey, and collectively they actually bring 60 years of prosecutorial experience as part of this team that analyzed over 50,000 pages of trial transcripts from 2 months-long trials, thousands of pages of confidential prison files for both Eric and Lyle Menendez. They were with me as I spoke for over 3 hours with the Menendez family members and heard all their thoughts and perspectives. I spoke with defense counsel, I spoke with prior prosecutors, and I spoke with investigators. And in doing that, we analyzed the 3 different courses that the Menendez brothers had sought to be released from prison. One we've already dealt with before, which is the resentencing that led to a parole hearing. The argument we made there, which we have made consistently, was not never, but not yet. In other words, that when we looked at both the resentencing issue and ultimately the parole issue, we determined that the Menendez brothers had never come fully clean with the central defense that they had articulated during trial. That's the self-defense defense. That they said, in essence, that the reason they killed their parents is they believed their parents were going to kill them first the night of August 20th, 1989, so they had to brutally shotgun them to death in order to make sure that didn't happen. We showed that was a bald-faced lie, a lie that the Menendez brothers persist in telling for the last 30 years to this day, by showing that they bought the shotguns that ultimately killed their parents 2 days ahead of time in San Diego under fake names, that they then had a pre-planned alibi set up for that particular night. They were going to be going to Batman the movie and even tried to purchase Batman the movie tickets after the murders. They'd actually practiced with the shotguns the day before. And when they killed their parents, they did it methodically to look like a mafia-style hit, shooting the dad from the back of the head. The mother, who lied bleeding on the ground, they actually reloaded a shotgun and shot her at point-blank range in the cheek. And then to complete the mafia facade, they shot him in the kneecaps. Afterwards, they methodically got rid of the evidence, the shotgun shells they picked up from the floor, the shotguns and the bloody clothing that they disposed of, either in a car wash dumpster over the side of the Mulholland freeway. And then they ultimately came back to their house, called 911, and screamed, "Someone shot our parents," and never came clean with it until tapes eventually emerged months and months later. But at trial, they persisted in saying, not that they were sexually abused as the excuse for why they killed their parents. And I want to make that crystal clear. Each Menendez brother was asked during one or both trials, is the reason that you killed your parents because they sexually abused you? Answer under oath, no. So then what was the reason? Because they said our parents were going to kill us that night. Not just dad, but mom too. So we had to blow them away first. That self-defense defense, because they've never come clean with it, also coupled with their most recent violations in prison, awaiting a potential parole hearing, is why we first argued there shouldn't be a resentencing, and then we later argued that parole should not be given. The parole board eventually agreed with the positions that we took. So that was course number 1. Course number 2, which exists today, is a clemency course. And that's a course of action where they've made a direct pitch to the governor, who under the California Constitution has the unilateral power to go ahead and grant clemency and release the Menendez brothers, if he so chooses, today. Or for that matter, any day he has been in office since 2019, and any day he will continue to be in office until he eventually completes his service as governor. So that is the second course of action. Today, though, we're here on the third course that the Menendez brothers pursued, and that was a habeas corpus petition that they filed in May of 2023. What a habeas basically says is it's asking for a new trial. It says that if new evidence has come forward, new, timely, credible, admissible, compelling evidence has come forward, such that even one juror may be convinced that not beyond a reasonable doubt that you did the crime, that you can be entitled under these very limited circumstances to a new trial. So the Menendez brothers went ahead back in May of 2023, and they isolated 2 additional pieces of evidence that they said had never been previously presented at trial and met the rigorous standard of habeas review in order to get this new trial. One piece of evidence was a letter supposedly written by Eric Menendez to his cousin Andy Kano, supposedly around December 1988, about 9 months before the August 1989 murders. And the second was a declaration by Roy Rossello. It said he had been sexually abused by Jose Menendez back in 1983 or 1984. What we said then, what we said in our informal opposition, what we said in our formal opposition, is that these two pieces of evidence didn't meet the procedural requirements to be even considered to get a new trial. Those are the procedural requirements of being, well, let's start with new. We said a letter from 1988 from Eric Menendez to Andy Kano, both of whom testified at each of the trials, and neither of whom testified that this letter and communication existed. In fact, each of them testified at the last communication they had about the sexual abuse that Eric Menendez had experienced was 6 years before 1989, when Andy Kano was 10. Eric Menendez was 12 or 13. And they had not had another communication about it since then. But lo and behold, they found this letter, supposedly after the trial, even though it was written 9 months before the trial. Eric Menendez didn't testify to this letter or its existence. Andy Kano did not testify to this letter or its existence in 2 different trials. So we argued that it didn't meet the new qualification. We said it wasn't timely. They had this letter 35 years ago. To be timely generally for a habeas petition, you have to have found stuff that was within you have to file the motion within 5 years of discovering the new evidence. At best, this letter was used during a 2015 Barbara Walters television show, and they still waited till 2023, so we said it wasn't timely. We said it wasn't credible. How can you believe this letter actually existed when nobody testified to its existence in 2 different trials? And we also said it wasn't material or significant that would lead to a new trial. What we said about the Roy Rossello declarations, we made the same arguments, that effectively it wasn't timely, it wasn't new, it wasn't credible, but especially it wasn't admissible, because the new evidence has to be admissible. But how can something that occurred back in 1983 or 1984, which each Menendez brother said they had no idea existed, how could that have influenced whether or not the Menendez brothers decided to kill their parents in a premeditated and deliberate fashion in 1989? Because at that moment, August 20th of 1989, they had no idea whatsoever about what had happened between Roy Rossello and their father, Jose Menendez. In fact, they were not to learn about this for almost 30 years later. So we said that too shows it does not meet the procedural hurdles to even get to the question of whether or not it would actually result in a new trial. So what Judge Ryan did yesterday, in agreeing with our position, our ultimate position, and ending, for now, unless they keep appealing this, the meritless motion that the Menendez brothers filed, he basically said that the evidence alleged here is not so compelling that it would have produced a reasonable doubt in the mind of at least one juror. That is how deficient, how meritless, how baseless the evidence that has been presented by the Menendez brothers has been in this habeas motion. So Judge Ryan has put a full kibosh on the habeas motion here. So now we have the resentencing/parole course has not resulted in the Menendez being released. The next parole hearing is scheduled for 3 years, although the parole board could advance it. We have the habeas petition now that is ended. The Menendezes could always appeal it if they so choose, and I trust that the appellate courts will reach the same result that Judge Ryan has reached here and find it utterly meritless. And then there's that clemency path that the Menendezes have always had, in which the governor can grant them clemency if he so chooses any day he remains in office. So again, let me thank the prosecutors who have spent an enormous amount of time, effort, research to make sure that we got it right. And that was the goal. Let's put in the hard work to make sure we get all the facts in front of the judge so that the judge can then make a decision based on the entire record, not just some parts of the record that certain Netflix documentaries, certain parts of the social media has picked on. We laid out in over 130 pages what the entire Menendez record looks like, and Judge Ryan read our submission, relied on the record, and denied the habeas motion. Let me stop there and answer any questions. Yes?
Your predecessor had said that the brothers have served their time and repaid their debt to society. Does this bear any weight in your decision making? And if so, how?
What we decided in our decision making is to ground it into the facts and the law, not some aspirational desires of a particular district attorney, but whether or not it met the facts and the law of a habeas petition or a resentencing motion or ultimately a parole petition. And that's what we've done. So regardless of what I think or feel, that is not played the role in the positions that we've taken that have done this rigorous analysis of the facts and the law, resulting in ultimately this habeas petition being denied, and the Menendezes, ultimately they did get resentenced, but their parole being denied at this point. Any other questions? Yes?
Have you spoken to the extended family of the Menendezes since the ruling?
I have not. Other questions? Yes.
The Judge Ryan's decision, maybe I misunderstood this, but in his denying their petition, he specifically related their new pieces of evidence to the special circumstance factors and the formation of a first-degree murder case with a special circumstance. Could you just unwind that a little bit and help me understand why that is the significant piece of this as opposed to guilt in general?
Certainly. So he looked at one additional factor, which was the special circumstance of lying in wait, which is sort of an additional circumstance to just being engaged in premeditated deliberate killing of your parents. In other words, you could go ahead, Menendez brothers could have gone ahead, had some relatively minimal level of planning, some planning of forethought, grabbed the guns, shot their parents, and that could be premeditated killing. Lying in wait requires additional factors. It means you have to surprise someone. You have to actually plan it out. You have to plan it out when they won't be suspecting that was going to happen. In this case, the Menendez, both Kitty and Jose Menendez, it's about 10 o'clock at night. They're sitting in the family den watching TV. They had a UCLA application for Eric Menendez sitting on the table, and they were completely unsuspecting that their two sons were about to burst in with shotguns and kill them dead. So the additional facts that have to be proved in the special allegation were both proved beyond a reasonable doubt and found by the jury. The key part of where Judge Ryan was focused is this concept of experiencing a fear of imminent peril. That was the self-defense defense. That if you experience this fear of imminent peril, then you basically have the right to defend yourself. Now, the difference between an imperfect self-defense and a self-defense would be this. If you assume that your parents are in the room and they have shotguns loaded and they're just waiting for you to pop out, and as soon as you pop out of the door, they're going to unload their shotguns onto you. And sure, maybe it's a little dark and you can't see it, but you think they're holding the shotguns, they're about to shoot you. Then you burst into the room with your shotguns and you shoot them. Turns out they don't have the shotguns. Even though by all means and factors and all the evidence you believe that the second you open that door, they were going to blow you away. That would be an imperfect self-defense because it turns out they didn't have the guns pointed at you. A self-defense defense would be, yeah, the guns were pointing at you and there was a shootout. You killed them before they killed you. So what the judge found is even for imperfect self-defense, the imperfect version, there was no evidence of it. And more importantly, these two new pieces of evidence, Eric Menendez's letter to Andy Cano about sexual abuse. Well, he testified. Eric Menendez testified for 7 days on the stand in the second trial, detailing the sexual abuse he experienced from his father from the ages of 6 to 18. He even talked about communicating with Andy Kano about it 6 years before, when he was 12 or 13 and Andy Kano was 10. Andy Kano testified that, yes, when I was 10, Eric Menendez shared this information with me, and both of them said they had not communicated about the sexual abuse since then, though the letter is written approximately 9 months before these shootings. The judge said with that letter and the Roy Rossello declaration, which both Menendez brothers said, we had no idea that our dad was doing anything with Roy Rossello when it happened back in 1983-84, when they were killing their parents in 1989. The judge basically said neither one of these new pieces of evidence would go into their mindset to understand that they had a fear of imminent peril when they burst into that room on August 20th, 1989. So what the judge basically said is, I'm not going to deal with all those procedural arguments that the prosecution made about timeliness, new evidence, admissibility or credibility. I'll just jump to the end of the analysis, which is the additional evidence that it would show fear of imminent peril? The answer is no. Was the additional evidence such that it would have produced a reasonable doubt in the mind of at least one juror? And the judge said emphatically no. Yes?
So could you address the Judge Ryan also addresses the subject of the new evidence that was presented versus premeditation. Could you explain what that means, please?
Sure. So premeditation, I'll give you the difference between premeditated murder and we'll call it a voluntary manslaughter. Voluntary manslaughter is the classic definition is someone bursts into a room, they see their spouse with somebody else, they get enraged, they give no thought, and they kill the person that's with their spouse or their spouse. It's a heated passion. It's spontaneous almost. It's impulsive. Premeditated means you thought about it. Going ahead and buying shotguns 2 days before under an alias in San Diego instead of Los Angeles, practicing with the shotguns the next day, pre-planning your alibi before you've gone ahead and killed someone, and you fear imminent peril, and then actually going ahead and trying to buy the Batman the movie tickets afterwards, staging the killing to look like a mafia killing, and then screaming in a 911 call that someone killed our parents. These are the steps that the prosecution back over 30 years ago, and we through our papers laid out step by step by step to show that the Menendez brothers didn't just have a voluntary, impulsive, heat-of-the-moment decision to kill their parents, but they thought about this for days. What they say to the psychiatrist in the taped confessions is that Lyle Menendez had the idea of killing his father well over a week ahead of time and presented it to Eric Menendez to make sure that they were not only comfortable killing their father, but killing their mother as well. And the reason that the Menendezes gave to the psychiatrist, which is taped, at the time why they wanted to kill their mother, is that it was either a mercy killing. They thought that she couldn't live without their father, so they were doing her a service, or they didn't want to witness to their father's killing, so they had to kill her as well. So that evidence came out at trial, and that's the evidence we relied on to show the evidentiary record to the judge to explain why this additional new evidence was not any additional evidence dealing with imminent peril or the self-defense defense. It was some additional sexual abuse evidence, which was not their central defense at the trial. And Judge Ryan agreed with us. Yes?
Hi, so you said the governor at any time could give like clemency to the brothers, so they could pretty much get out any time. Why do you think it's taking so long, even though the public wants this to happen? Curious.
Well, whether the public wants it to happen or not, Governor Newsom has had this on his desk for a long time, well over a year, maybe 2 years at this point. He does not have to share with us his processes to understand whether or not he's going to release them or not. At one point he said he was going to see how the parole board analyzed the situation, and that may influence how he decides to release them or not release them. But well before the parole board ever got the case, well before the Menendezes ever filed a motion Remember, he's been governor since 2019. At any point, any day he could wake up in the morning, sign a piece of paper, and the Menendez would be out that afternoon. He's chosen not to do so, but it's his choice for whatever reasons he wants to give for it. Any last question? All right, well, thank you all very much. Appreciate it.
Thank you.
They might back there. Are we good? Yeah. Okay. Yeah.
You know, there are cases where
Yo tengo, ¿sí?
They ran it.
¿Sí? Dale. Prenderlo.
Okay.
Ahí está. Me vas a mirar a mí, pero
Está bueno.
estar nada más de posicionarte. Espérame tantito, compañero. Un poquitito más atrás, así está bien, ¿no? Ok, no te me muevas.